Before the High Court was segregation.
Sorry, my lord.
You argued segregation before the High Court.
Yes, my lord. And my lord, if your lordship sees the High Court judgment, kindly, my lord, permit me the three options which the High Court itself notes. At page 250 in the main petition, my lord, or if even in my petition, page 250.
Yes.
Sorry, my lord. Just give me 1 moment. One second, my lord, please. The High Court notes that there are three options before the High Court, and that your lordship will find at page number, my lord, (255) of the paper book, which is paragraph number 312. A PDF page 295. At the foot of the page 312.
In the main act.
Dismiss the writ petition, my lord.
Yes.
Dismiss the writ petitions on the ground of maintainability or explore the possibility of segregating the valid appointment from the illegal one, or set aside the selection made in the selection process in the entirety.
Yes.
So the High Court did have kept these three options, my lord, in mind. And then, my lord, if your lordship see below that, first option noted above is no longer available in view of the decision rendered on the issue of maintainability. That is on the limitation part, etc., that people came to the British court after, my lord, the expiry of the panel and 3 years after the appointments had been made.
Yes.
And then on the second option, my lord, the consideration starts from page 314, para 314, and if your lordship will kindly come on this aspect at page number, what they say, my lord, in para 321 and then 323. In respect of the four categories of the selection process involved, written examination has been held. Written examination in the form of OMR sheet. Original OMR sheets have been destroyed. Mirror image of the destroyed OMR sheet was required to have been preserved. CBI had seized the server of SSC and did not find any mirror image of such OMR sheets. So SSC and authority within the meaning, etc. I'll skip that. Now kindly come to 323. See, significantly, it is a claim of the SSC that scanning of the OMR sheets had taken place at its office. If that be so, then SSC had knowingly allowed another organization to scan the OMR sheets, namely so and so, who was not authorized. This raises serious questions as to the integrity, sanctity, and validity of the entire selection process and going to the root of the system. So this is the basis for not segregating, my lord. The second option, not opting for the second thing, that whether we can segregate. And then 260, para 330 onward, the third option is considered thereafter. So I am respectfully submitting, my lord, that I am not in any CBI list. There is nothing, no such thing against me. There are government orders. I have. Lord, at page 703 in my paper book, Lord, in my 17.6 item, we have annexed the pay protection granted by the government, and the carry forward of the service book is at page 705. 703, statement of protection, and thereafter approval of that fixation of pay and protection by a superior authority, and then the service books are from 705. Lord. We have annexed one of them because there are 367 people we have, and that's why we have put it in a chart. So it shows, my lord, memo of 2008 at serial number 11, if your lordships have 703. And then 2014, and then the current. And over the page, my lord, is the approval letter. At the top of the page says approval of fixation of pay for protection of pay in respect of in-service teachers. So we are called in-service teachers, my lord. And that protection of pay happened on 16/12/19 at the foot of page 704. And the service book of this first petitioner is at 705. So, but I am, Millard, so therefore I have started by saying we are a sui generis category, Millard. Because we are not somebody who has in-service candidates were allowed to give, Millard, and if a lordship were to just permit me to show page 389, which was a public notice issued by the West Bengal School Service Commission, allowing us to participate. And of course, I must point out, Millard, that we had to go to the High Court for allowing us to participate, because the scheme for the centralized recruitment happened for the first time in 2016. So we went to the High Court. That High Court order is also on record, saying that yes, we should be allowed to participate. And then, Millard, the public notice came, which is at page 389, which extended the period for filing filing our application up to 7th October. And one is to retire next year, as I pointed out, Millard. Yes. I'm very grateful. Much obliged.
Yes, Mr. Diwan.
May I be excused, Millard?
Yes, Mr.
Can I follow that order? Because I will be also representing those persons against whom Mr. Brooks.
You are Mr. Pratik there? All right.
And I prepared a short note. Well, my endeavor, since I have also lost the job because of this judgment, my endeavor before your lordship shall be to show the gross incorrectness in the judgment itself.
Yes.
But first, lordship may kindly see the very basis of this judgment, which is challenged before your lordship, was the November's order passed by this honorable court. In the order, there are 7 fundamental directions which were required to be gone into and followed by the honorable decision bench. Lordship, kindly take the first. I have just jotted down that. The first point was, Lordship may kindly put a difference between two situations. Usually, my lord, whenever the matter is heard by your lordships, send the matter then there is an expectation that the matter will be decided on merit. But there are only few cases when your lordships feel that not only the merit is to be decided, no matter it was pending for last 3 years, 4 years, etc., but also the point of maintainability is to be decided, then, my lord, my respectful submission would be that there should not be any prejudice as long as this order stands. So the first part of the order was, though there has been detailed documents, all points, this honorable court felt for whatever reason that there is a necessity to first decide the maintainability of the writ petition itself. The second was to examine the admissibility of the OMR sheet images. Third was in November 23, when all the documents, affidavits by the CBI and School Service Commissions, everyone was before your lordships, there was an observation in paragraph 8. At this stage, no such outstanding case, because Justice Gangopadhyay passed an order for termination of the large number of teachers. So this was the observation by your lordships. Fourth was, these allegations would have to be established through evidence. Well, I would correlate on this score how the Honorable Division Bench have completely gone incorrectly. Fifth was, well, this is important, to ignore the findings of the earlier Division Bench on Rule 17 plus to decide afresh. Lordship may kindly connect this with the point of maintainability. Because the situation at that point of time, my lord, before this Honorable Court was that the Honorable Justice Gangopadhyay directed the School Service Commission that you must invoke your power under Rule 17. My lord, School Service Commission is a recommending authority which is governed under a particular rule, for the time being 2016 rule. Once someone is appointed on the basis of a recommendation, as an employee, I am governed under 2018 rules, which is a separate rules altogether. A point was taken before the High Court, before the Honorable Justice Gangopadhyay, and also before the then Division Bench, that once the recommending authority recommends and thereafter an appointment is done, the recommending authority becomes functus officio. But there was a direction by the Justice Gangopadhyay to the recommending authority that you invoke Rule 19, Rule 17, by which you terminate all the ballot, whoever at that point of time the court found that their appointments were illegal, invoking Rule 17. So that point, whether that would be done or not, that was required to be decided, that your lordships held. Now last one, and the next page, CBI to complete investigation and submit its report. Well, this is very important. Lordship may kindly see that after this order, this was a November 23 order. After this order, well, what is usual and what is expected is that the CBI will file a report before the Honorable High Court saying everything, whatever they have got to say. But there are 3 reports which were filed by the CBI. First report was of dated 9th of January 24. That does not contain anything of 65P, anything of scan take, anything of whatever is found to be fundamental today before your lordships. Nothing. Absolute absence. Thereafter, after 19 days, second report was filed by the CBI, 16th of January 24. Lordship may be surprised to take note, in the entire report, there is not even a single word on scan take. I have seen that on the very first day when this matter was moved, one of the basic points that was expressed by your lordship, that how there can be somebody who was not even getting the tender, that's a scan take. So that's an important issue. So after 19 days in the report for the first time, my lord, first 9th of January, nothing. Not even the 65B certificate. Despite November order, there is a requirement to prove it admissibility. 16th of January, no whisper, no word, no sentence, no document on Scantech. Last report, 5th of February 24. Now, Lordship may kindly look at two fundamental, according to my understanding, flaw. My Lord, after the amendment of the Evidence Act of Section 59, if a particular record happens to be electronic record, the only way of that electronic record to become an evidence is 65B and 65B alone, as held by your lordships in Anwar judgment. Now, there are two sets of electronic records as per the last report of the CBI. One Scantech, one Pankaj Bansal. Lordship may kindly have a look at, my lord, I am referring to the state SLP for the convenience, page 768. Lordship has got. Lordship may kindly have a look at this. This is signed by authorized signatory Sri Pankaj Bansal, data analyst, Messrs ND Infosystems Private Limited. But I could have understood. My lord, if I can give an
So
example.
what's the drift of your argument? We're not able to get-
May I just say and then?
Yes.
I was just thinking of a situation. My lord, as a counsel, now if I sign here, I am signing in the capacity of, my lord, as a counsel, as an advocate. When I go to my son's school, when I sign there, that signature is not, my lord, in the capacity of a counsel. As a parent, I am signing. I do not say that Pankaj Bansal could not have signed in the capacity of an ex-employee of NISA. I don't say so. I say that this is having not done so. Can you have a look at, my lord, who has signed it? Signed, I read it out. Authorized signatory, Sri Pankaj Bansal, data analyst, Messrs. ND Info System Private Limited. Well, this document is absolutely nothing.
So there is an absence of data. That's the whole point.
That's what I come. It's not correct. That's not correct. First, what I submit before your lordship is this. In November 23, this Honorable Court wanted the High Court that look at the 7 points, decide the writ petition, including the point of maintainability. If you have to issue any order on the OMR, first decide the admissibility of this OMR sheets as, my lord, seized by the CDI. Now, what I, my lord, submit before your lordship is this. Your lordships have categorically held that it is 65B certificate and certificate alone. Well, I shall be showing that specific paragraph, not the affidavit. Must disclose what is required in the 65B. Now that will come only after someone, my lord, who is relevant with the organization, he is, my lord, giving a certificate. Today, I could have understood a certificate is given by the Scantech. I would have understood a certificate is given by any employee of the NISA. But this certificate is by X, Y. So this has got absolute zero value as far as the evidence part is concerned. Now, lordship may kindly take, my lord, the last but one page of my note. Lordship may kindly take, my lord, the Anwar judgment, my lord, in the compilations I have given.
We'll see that later. We'll see that judgment later.
My lord, that paragraph 14, if I can read it out, my lord, the relevant portion. Any documentary evidence by way of an electronic record under the Evidence Act in view of section 59 and 65A can be proved only in accordance with the procedure prescribed under 65B. So that's the only way out. Now thereafter, I'm skipping few portions. 14, last 2 lines, which is called as a computer depends on the satisfactions of the 4 conditions under 65B2. Now, lordship, kindly take last part 1 page of myself. What, if I can use the word, the blunder the CBI has done? My lord, they have stated in the certificate, I have the exclusive possession of custody of the records. What is required under 65B2A is a lawful control, not the exclusive custody. There is no word, because I can take on the face value that, yes, he is saying I am in the lawful control, that is fine. But there has to be words like lawful control, that's a requirement of 65B2A. Instead of the word lawful control, the word that's there, having exclusive custody. Well, this is the first. Second, there has to be a specific statement in the certificate, my lord, that it is regularly fed plus ordinary course of activity, that is 65B2B, completely absent. My lord, third requirement was computer was operating properly, 65B2C, absent. Last was information equals to reproduction of what was fed in computer in ordinary course of activity, 65B2D. So therefore, the four requirements under 65B absent in the certificate given by Pankaj, who is not even of NISA. One. Other thing is the Scantech, which in the last report of the CBI has said that he has also done better scanning. There is not even any certificate by the Scantech. Now, in this context, now Lordship may kindly come paragraph 335, for which we have lost our job. 330. That's the 17 reasons. Well, I just forgot to indicate one more reason. In the last report regarding the data of the Scantech, Lordship may take note of the fact that what the CBI said in their report, that they see some data in the form of .dat. In the protocol for any scanning, the data has to be in the JPEG or the TTF file. That's the protocol. But it can always be converted to .dat, but that requires another software. The reason for this submission is that technological aspects, a little tweak can make a huge impact. That's the requirement of 65B very stringently. So,
All right, we'll hear them on the 65B.
Yes.
Let's anything else?
Yes, 335, the first reason that we lost our job, that SSC has appointed the agency, namely NISA, for the purpose of scanning and evaluating OMRs by a closed door. Lordship may kindly consider this. For last 7 years we are serving. I don't have really information, but my instruction is that many competitive examinations, because of the reason that the candidates do not get to know who would be doing the AMR, it is done in the closed door. But I don't have the data. That's the instructions I have got from my clients. Now, High Court could have at least made an attempt to see, is it an unique thing which is done by the School Service Commission in West Bengal, or in all other competitive examinations, the closed door is the common phenomena, because so that the candidates do not get to know this. The second one was why the data Scantech was there. Lordship must. My lord,
Mr. Dar, now let's hear some other people also.
just 2 minutes.
Yes.
My lord, the rule 2016 rule, Lordship may kindly have a look, rule 21. But I don't say that it's a very proper rule. It should have been better. But the rule requires that this has to be destroyed.
But the scanned mirror images have to be preserved.
That is not in the rule. That's not in the rule. That's, my lord, the common sense I can say. I can say, yes, it's a good thing, it's a transparent. But to say that the rule requires that mirror image should have been there, but that's the findings of the division. That is incorrect. Lordship may kindly have a look at the rule.
There's no requirement of
No,
maintaining a mirror
no
image.
requirement. No requirement. And my lord, the RTI.
Rules without coming really supersede the parliamentary step of RTI.
Well, may I hand over the, my lord, this 16 rule? And Lordship will not find a single sentence. 24,000 persons have lost their job. But among 149, my lord, as I am representing, there is one wish. But I do say, as a responsible counsel, I do say, my lord, this rule is not proper. That Lordships always come across. It is definitely not proper. But at the same time, as long as the rule is there.
But is it, according to, is it possible to segregate those who are tainted from those who are not tainted?
Well, there are two ways of looking at it. One, Lordship is assuming that some people are tainted because.
According to you, nobody is tainted. According to you, nobody is tainted.
Well, I am representing that 19,000.
Where do you stand? I mean,
I say on a point of law, when this honorable court directed that you have to decide admissibility.
but according to you, is the entire process without taint, or there are people with?
No, there are, I would say, tainted persons. Who are those tainted? Who have been given appointment after expiry of the panel, number one.
Yes.
Anybody who was given appointment after expiry of the panel, of course, this is illegal and that can easily be found out from the very date itself, and they should go.
Then,
my lord, if there is,
apart from this category,
my lord, if there is any candidate who even without participating has got the appointment, must go. It's illegal.
yes.
All I say, my lord, the parameters of illegality, Lordships definitely apply. But if your Lordships apply the parameters of illegality after observing or finding that there is a sacrosanct electronic records, that is absolutely right. And therefore, what is the wrongs has to be found out after seeing what is the mismatch from this one. That is only permissible once that electronic records are found to be correct under 65B. But on the face of it, tomorrow somebody else gives a certificate. This would be, my lord, allowing an amendment to the 65B itself. And to that effect, my lord, the only submissions by the counsel of the CBI was one paragraph in his entire judgment, paragraph 29. We have submitted our charge sheet, matter is pending. That's all. There was no answer to my very fundamental point that this is so important. Scantech, NISA, why didn't you say so at the first time? Why didn't you say so in the second time? And why you are saying at the last time? But I have a probable answer. They knew that 65B certificate signed by someone, some MD Electronics, that is legally, that has got no value, zero value. That's the reason in November 23, they did not show it before this honorable court. That's the reason in the first report, they did not annex it. Only in the second report, they annexed it. And in the last report, my lord, a new story of the Scantech came, which I said that there they are referring to .dat format, which is a processed. But today, I am also representing visually challenged candidates. about 100, though only one person has signed and is before your lordship, they have also lost a job because of this judgment. My lord, my respectful submission before your lordship would be that the criminal case is pending. Ultimately, it would be decided who has done what and he must be punished. Prior to that, in a writ proceedings, whoever has jumped the panel, they should also go. But other than basing that this is the CBI record so sacrosanct may not be a proper interpretations of.
Thank you.
These are my responses.
Yes, Mr. Who's now going to argue? Maybe the next counsel under the. Mr. Rawatgi is here.
I am there.
All right. Now we have Mr. Madial, right? With
I
Mr.
just take
Rawatgi.
3-4 minutes. I'll not take more than that. Much of what I
1 second. We'll go. No. We'll go by the rules. So we'll go by what we have got the record now. No interventions. Yes.
I appear in item 17.2, 10.5, 17 and 18.
All right. What do you have to say?
Yes, Manoj. My submission is that segregation was possible and it ought to have been done. The petitioners in these matters, Manoj, are all persons who are completely untainted, even if the OMR is to be taken as correct. The mirror image of the OMR is taken to be correct. In fact, if my lords have para 240 of the impugned judgment, the SSC 240, that is para 240, PDF perhaps 243 minutes. 249. There is already a segregation that was placed before the Honorable High Court.
249.
Yes, para 240, Manoj, sir.
The page.
Page
PDF?
200, PDF page is I think 249 of the state's SLP minutes. There's a tabular column at the bottom of it.
Para 249.
No, para 240, PDF page 252, I'm told. PDF 252.
243.
252 of the state SLP. Yes, so there is a segregation, and my lords may just note at the right-hand corner of that table, the discrepancy found even, for example, in 9th and 10th level is just 8.5%. The CBI finds, my lords, discrepancies after examining the OMR sheets, the mirror image, in respect of about 953 candidates, in respect of most of whom there was, my lords, a withdrawal order issued, which was stayed by your lordships over here. But my only point is that segregation was possible and segregation was done. And therefore, my lords, today, in the 9th and 10th level students, there were 11,610 candidates who were selected. Out of that, my lords, as per this table, I am going by this table.
Yes.
As per that, even according to the SSC in this, the alleged irregularity was only 993. Therefore, my lords, if segregation was possible, as the SSC has told your lordships today, it is possible. The CBI has identified those individuals. The SSC before the High Court has placed data identifying those individuals. There would be no reason, my lords, to paint all of these candidates with the same brush. And to remove them. And this would especially be so, Manoj, because 2018 these individuals have been appointed and are continuing to work.
All right. Thank
Grateful.
you. Mr. Diwan.
Manoj, just one suggestion, one aspect. Manoj, your lordships may also consider if segregation, if today the data which the CBI has is to be examined even by an independent committee to see if that segregation is valid or not. Grateful.
I have two sets of submissions to make. The first is in the petition, which is at serial number 19.3. It's titled Chinmoy Mundal. Now, may I just make my point here? There are three petitioners here, three SLP petitioners before your lordship in this particular petition. None of them were parties before the High Court. And we've therefore come here with leave to appeal this particular judgment. Now, I come in what can be broadly described as that untainted category, and this is very important. So 2 points I'll make straight away. First, I'm in the class 9 and class 10 band of assistant teachers. Second, I am not, in a manner of speaking, tainted either by the OMR issue or by the rank jumping issue. Nevertheless, the impugned judgment in para 363, Roman 2 says, all appointments granted in the selection process involved being violative of Articles 14 and 16 of the Constitution are declared null and void and cancelled. So one more fact I want to mention. At page G of my list of dates, I have given you the dates, so I'm not going into those specifics. I was appointed in 2018 and 2019. There are 3 petitioners. So between 2018 and 2019. I've been in harness for more than 5 years. Apart from being in harness for more than 5 years, Manoj, we've taught over there as assistant teachers in class 9 and 10. There's absolutely nothing against me. There's no finding. I'm not on any list of any CBI or anybody at all. Now, in this backdrop, let us go back to this paragraph 240 for a moment and just study it a little carefully. The 3 bands in para 240, which I understand is at PDF 252.
Yes.
Now let's see these numbers. I'm on the first band of assistant teachers. 11,610. Now I ask, the question I pose to myself is, could this have been done through an executive order? I believe if it were done through an executive order, this type of cancellation, that everything is going out, your lordship should have struck it down as treating unequals equally, which is completely wrong and has been frowned upon. Now, out of 11,610, the OMR issue, assuming there is an OMR issue, is only for 808. Now, look at the second column, rank jumping. I am not, as I mentioned, I am not on the
OMR issue is that the OMRs were not available.
There were some blanks, there were some available. But this is only what now, this is post whatever the value of that investigation by the CBI.
On what basis did the SSC submit this statistical report? Now we are taking this report.
Because there were lists which were filed by CBI, for example, which were there. That list is also appended in annexures to this document.
Are those OMR sheets recovered from the residence of that Mr. Pankaj? That's the start and the end of the CBI's investigation. The CBI says that in some of those OMR sheets, some people who have got 0 have been selected. Now, that's the whole case of this. So, if that record which is recovered from the residence of that gentleman and that certificate has been attached.
How many OMR sheets have been recovered from Bansa's residence?
Mirror images. But number is, there is no number. There is no number given anywhere. If you will read the last of the CBI, the scanning was done, the board was to scan. Board A to scan. Agency A gave it to agency B. This Pankaj is the employee of that agency. Then some employees of that agency split and make their own private agency. And then Pankaj goes and joins those employees. And he has given a certificate as an employee of that split agency on the basis of record which is recovered from his house. And 25,000 people are losing their job. That is the whole open and shut case finished. The judge has addressed no other argument which was raised before him. And how did we lose our job? The single judge who was hearing the case, in one order says, this is a case where the board should exercise power under 17. 17 is a power with the board to withdraw recommendation. The board says, yes, we will look into it. We immediately file an appeal before the division bench. And we tell the division bench that we have been working for 4 years. Single bench in a 1-page order says, board to look into it and exercise power under 17. Division bench says, yes, you have no right to be heard. Finding number 1. Finding number 2, 17 will apply. The same day when the division bench passes the judgment, The same day the board passes an order withdrawing our recommendation. And the next day our services are terminated. We come before this court here. Your lordship stays the termination. Your lordship stays the termination and says they should have been heard. And your lordship says, please go into the issue whether Rule 17 at all applies after a person is appointed and has served for 4 years. Now, all those arguments are raised. Not a single word on Rule 17. The petition challenging the vires of Rule 17 is separated, segregated, and not decided. And the whole judgment is based on this 65B certificate.
Mr. Patwalia, Bansal signed the certificate in what capacity?
My lord, as an ex-employee, just kindly see one paragraph. Just one minute. Just kindly see one paragraph in the judgment, para 305. The whole cat will be out. Just see para 305 to answer this question of my lords. Who was authorized, who did it, and who gave the certificate? This is a matter of Lord.
Certificate is at certificate is at para 305.
Yes, just kindly see, Shyam, can I just show? Just kindly see para 305 of the this is the last report. CBI has filed several reports in these proceedings. In its report dated February 5, 2024, filed in compliance with the court order dated January 24, it has stated as follows. During investigation, it was revealed that the West Bengal School Service Commission, hereinafter referred to as the Commission, had awarded work order to Messrs. Nyasa Communication Private Limited, referred to as Messrs. Nyasa, for scanning and evaluating the OMR sheets pertaining to the selection of Group D, Group C, so and so. Investigation has established that Puneet Kumar was the then director and Niladri Das was the then vice president of Nyasa Communication during relevant period. It has been established during investigation that Shri Niladri Das was in charge of operations in respect of recruitment examination conducted by the West Bengal Service Selection Board, frequently visited the office to attend the actual operational part, did the requisite liaison on behalf of the agency for necessary compliance of instructions. Shri Puneet Kumar, being the director, mainly looked after financial affairs. Now what happened? Investigation has established that scanning of OMR sheets was undertaken by NYASA at the West Bengal Secondary Board Office at Acharya Sadan under direct supervision of Niladri Das in the presence of WBSCC officials. It has been further established that NYASA Private Limited had further given work order regarding scanning of sheets to Data Scantech Solutions Noida, who remained present at the premises for scanning. After completion of the scanning, the processed data in the form of scanned images of OMR, scanned data were handed over by Data Scantech to NYASA, who took the same to their officer located at Noida in digital form, leaving the hard copies in the office of the board. Board handed over their answer keys in respect of all subjects to NYASA. Now, none of these agencies is giving the certificate. I'll show who's giving the certificate. Your Lordship may now leave a few paragraphs and come to para 9. Because next paras they explain the files. Come to para 9. During investigation, the service database of the Commission was seized by the Central Bureau of Investigation, containing all data pertaining to selection test of Group B, C, D, so and so. During investigation, 3 hard disks were recovered from the residence of Pankaj Bansal, an ex-employee of NYASA located at Ghaziabad. Who is this person or how can this record be relied upon? It has gone changed 4 hands. Now it is in, they have picked it up from the residence. During investigation, these data files scanned, these 3 hard disks were recovered from the residence of Pankaj Bansal, an ex-employee at Ghaziabad. The certificate dated 16/9 of 65B from Pankaj Bansal was obtained. He has not certified on behalf of any of these 3 agencies. Now they'll explain who he has certified. Was explained in triplicate with regard to genuineness of the data concerned.
No, but what they say is the hash values of these data files of Scantech Solutions
Correct.
were matched with the hash value of the corresponding files recovered from the hard disk seized from Pankaj Bansal and was found to be matching.
Correct. So Pankaj Bansal would probably have get it. But I am nobody to say so. In the criminal trial, this matter is pending investigation. Today, you take this as the gospel truth and throw out 25,000 people. Now, how this company is formed. Now, if your Lordship will see, your Lordship has just read para 11. Now, if your Lordship just kindly come to para 15, just come to 15. What has happened? That original company split, just let me read para 15. That it is emerged from the investigation that before leaving NYASA, Niladri Das and his staff
were identified in CBI.
Just let me read. Sorry, para 14 onwards. It'll come. It is coming. Yes.
Of the CBI seems to indicate that the candidates in respect of whom there was a mismatch of the data have been identified.
Correct.
This mismatch establishes that the manipulation of marks of the written examination, the case of many candidates was resorted to and such candidates were identified. The comparison of these actual genuine OMR marks with the OMR marks available in the server shows that there is manipulation in 952 numbers of candidates for 910, 907 for 1112, 3481 for Group C candidates and 2823 for Group D candidates.
Apart from the fact that this segregation is possible, I am on a more fundamental point. My fundamental point is, how is this mismatch coming at all? The mismatch is because it is mismatching from what is recovered from Pankaj in his residence. Now, please read with me para 15. It's very important. 14 and 15 is very important. What happens to this data and where all has it gone? Just see now para 14. Para 14 and 15.
All right, read 13 also.
Yes, 13, no problem. That during investigation, several emails were found to have been exchanged between the accused officials of the commission, certain private persons, and officials of NASA. These emails contain lists of candidates whose OMR marks were found to be increased in the server of the commission. Besides, these emails have been exchanged between staff of NASA containing manipulated data of candidate. This shows complicity. This is all somebody's Dixit, Lord. But now let's see, read 14 and 15. During investigation, it emerged that in the year 2019, Shri Niladri Das of NASA Communication left NASA, started his own business in the name and style of Messrs. ND Info Systems. Now, this is the certificate coming. Now let's read further, Manoj.
CBI second deputy agent.
I'm trying to call upon the other side. If anybody wants to argue for a minute so that you don't have the...
Just one more paragraph. One more paragraph.
This is very serious.
Just to argue, Manoj. I need that.
Yes, yeah.
I'm going to argue for fundamental.
This is completely wrong.
How about Justice Gangopadhyay?
How are these people losing their jobs? They are vested rights.
What a grave miscarriage of justice has taken place. It was he who ordered CBI inquiry. Pending that hearing, he gives a public interview and speaks loudly about this matter and says, I'm going to send everybody home. But this is shocking what has happened. Your Lordship will have to take cognizance of it. We cannot allow this kind of judicial misconduct to go unpunished. He gave an interview, and I will read interview, my Lord, in which says, yes, I have political aspirations. And someday if somebody invites me, I will accept it. But this is really, and not when he took cognizance, there was no prayer for CBI.
Mr. Dave, before we go into these broader issues, can we just focus on what the nitty-gritty of the matter?
Yeah, we'll go into the nitty-gritty.
We are 6 years, we have worked. Your Lordships are right. Please then grant a complete stay to us. Even this 956 people, what happened? This magical dish was sent to Forensic Science Laboratory, Hyderabad, by CBI. They said we cannot even verify it. They said we cannot verify. Now, as Mr. Patwalia rightly says, this is subject matter of criminal investigation. But pending that investigation, should we be damned? I can understand after a judgment. But in cross-examination, this Bansal will collapse in a minute. So, my Lord, we are being damned on this so-called, and my Lord, one thing, when your Lordships remanded the matter, your Lordship said...
Can we just for a moment have... 1 second. Do you want to hear again, Mr. Jaideep Gupta here? We just want to...
There is only one thing, Your Lordship.
Just call Jaideep.
Lord, when your Justice, when your Lordships remanded... Abhishek, just a minute. Abhishek. When your Lordships remanded the matter, your Lordships expressly record, there is no evidence available on record as on today. Therefore, if there is any evidence, it may be put. Only evidence is this magical CD, which is completely inadmissible under section 65B2. It is not, the certificate is completely dehored 65B2 read with 65B4. Completely, read the certificate, my Lord. And your Lordship's judgment in 2014, which has said how this evidence can be taken. So, my Lord, we are being condemned after 6 years, my Lord. We have families. Nobody complained when Justice Gangopadhyay took the matter. There was not even an allegation of impropriety in that petition. I will show that petition. So, my Lord, it's something which is really a grave injustice.
I wanted to only intervene to alert one thing, Willis.
Just one thing. If you had a little bit of faith in the court, please sit down for 5 minutes.
All
Let's
right.
talk to the other side.
All right, all right.
We'll talk to the other side, hear them, and let's put our
Certainly,
doubts to them.
certainly, with one caveat for 1
If we
minute.
are, if after hearing them,
No,
Dr. Singhvi, if after hearing them we are inclined to dismiss your petitions, we will give you a full hearing.
I'm very grateful. I'm saying
That's the
something very.
least which you will expect from
No,
judges
well,
who are
the
trained with
question
the-
of not trusting
in
the
the-
court.
Great.
Well,
And the technical aspect.
I want 15 seconds to point out something Your Lordship doesn't know.
Give us-
I am awaiting my turn because I am going to ask Your Lordships to unhear whatever you heard. I am a category who is nowhere in the CBI list, nowhere in the
Singhvi, that's why we'll,
unrelated.
if we are
I'm the
inclined to come to the conclusion.
You haven't, Lordship, haven't heard our
If we
category.
are inclined to prima facie come to the conclusion that your petitions are to be dismissed, then obviously we can't throw your petitions out without hearing each one of them.
We are not started arguing.
Right? We just want to, we are conscious of the fact.
We'll wait our turn only on the technical aspect.
This understanding.
Therefore, your clients also should not get the impression that we didn't hear you and then we are dismissing your petition.
All right.
We have some doubts, let's put them to the other side.
Certainly, Lord, please keep in mind.
Jaideep, where is
Some of us
Jaideep?
are like this, who have not.
1 second now, please. Jaideep, is it possible, I mean, do we have any cogent material today to segregate the tainted from the untainted candidates?
That's right.
Now, you know that para 240, come forward. Para 240 of the judgment is a charge. Now, on what basis did you prepare the charge?
The digital data which they had obtained from that particular enterprise. And Milord, on that basis, it was prepared.
And we are out of that. That's the point.
And Milord, I may tell you, Lord, one more thing, Milord. Based on that same CBI data, Milord, we have issued letters of revocation of appointment for some people. In fact, Milord, 2 of the issues raised but not decided because of the nature of the directions later on. 2 of the issues raised was whether we had the power to revoke under Milord section 17, rule 17, and whether we in fact correctly revoked or not. These 2 issues were raised. So, Milord, partly, Milord, we have already done the job of segregation, Milord. We had already removed some people. We had
All the 5 lists by them for 5
Milord,
years, we are nowhere.
I am, Milord, only, Milord, saying that if your Lordship permits the data to be looked into, Milord, we will be in a position to segregate. If, however, if your Lordships feel that that data is not acceptable or, Milord, it doesn't have the necessary weight, Milord, then there will be a bigger difficulty.
Or a learned retired judge can segregate the chaff from the wheat.
No. First of all,
We need to show that to your lordships. This change in the creation, my lords, of one Mr. Pankaj Bansal, who is completely, my lords, incredible. His agenda was different. Ex-employee joining a competitor, and based on that, my lords, you create a taint. There's nothing to compare it to. There's nothing to compare it to. There's absolutely no evidence. And therefore, on that basis, a segregation is created because the commission wants to save some. That cannot be. They have to save all. There is no evidence.
Your lordships are dealing with
All.
your lordships are dealing with category B employees appointed or recommended beyond the expiry of the.
Well, let's hear the other side.
Milord, on this, Milord,
Now,
can I
we
just
have
take a
to-
minute? Can I just take a minute?
we have come along. Let's at least hear the other side.
Very well, very well.
Yes.
This is a job scam. Jobs were sold in the market at the price of 10 to 15 lakh. And when Milord,
Now, how many people stand to be affected by this order cancelling what's the total universe
the
now?
total without cancel should be Milord 22,930, 25,000.
25,000.
Now Milord,
Do we
none
have
of them-
precise figures?
Yes.
If you go to the synopsis at page B, we are considering 3 categories. Assistant teachers 9-10, assistant teachers 11-12, non-teaching staff group C, non-teaching staff group D.
4 categories.
Now 4 categories.
Total
Now, do we have a bifurcation among these 22,000 candidates? How many fall into each of these categories?
I just give you Lordship the detailed details.
Yes.
Milord, Joshua,
Some idea.
in group D,
This chart is a total wide. 240 has all the recommendations.
give us copy.
Extra copy.
Give us copy.
Recommendation was made 23,123.
This is yours, what you have given us?
Yes. Lord, this is on the basis of the data supplied by the school service commission, CBI.
Just please hand across a couple of copies.
And the illegal appointments total admitted till date was 8,000.
Now, 1 second. Just go step by step. Just 1 second. Give a copy, one copy to the other side.
Is this get?
All right. One, illegal appointments. Now, OMR issue, I mean, this OMR issue is a very vague statement. OMR issue is that how do you formulate the OMR issue?
That the OMR sheets which were recovered by the CBI was given to the School Service Commission. They have accepted that. School Service Commission being the custodian of the OMRs, they did not dispute the validity of the CBI retrieval, number one. Number two.
CBI retrieved these OMR sheets from where?
From the employee of NISA. NISA no more existed today. There are many situations which come for consideration. NISA had the Pankaj Bansal and Niladri. Now they have formed a new company. The CBI will raid it. They got it retrieved from Pankaj Bansal, who was the employee of NISA. And NISA no more exists today. That's very important. Now, when this retrieved disk were supplied to the SSC, SSC says that we accept this. We do not dispute the validity of it. The furthermore important, during the hearing of the matter, the Honorable Court gave everybody opportunity to see the OMR retrieved by the CBI. None has disputed that.
No, that is incorrect.
None of the candidates has disputed that. That's a fact recorded.
Now the OMR sheets contained a manipulation, or what was the problem?
The OMR sheets did not contain manipulation. OMR sheets were filed without any marking, zero OMR sheet. They have been shown to have secured more marks in the website of the SSC. That is the mismatch.
There is a discrepancy.
They have filed blank OMR.
In certain cases, there is a discrepancy between the digital OMR data and what is the final record maintained by the SSC.
Yes. Therefore, the OMR is the foundation which shows that there was a huge manipulation.
Yes, paragraph 59. The number of mismatches are all started.
This is a great scam. That's why we say. And this.
According to you, in your chart that you have given us, the total number of recommendations which were made were 23,123.
My lord.
According to you, taking your case at its highest, the total number of illegal appointments admitted until date are 8,324.
Which could be found as of date, because the SSC files an affidavit before the court saying that we could not yet reach to the final calculation. That's the affidavit SSC worked.
Right. But therefore, at the outset, I mean, the instinctive reaction is that if 8,324 appointments, according to you, are illegal, what is the ground for setting aside all 23 appointments?
No, my grounds are that entire selection process is tainted. Entire selection process.
How do you say that?
Starting from the appointment of NISA, the manner which was appointed, I will show the NISA people.
So assuming for a moment that NISA from the shaft.
Yes, I don't mind.
Right? So, then what is the justification for us today to uphold a direction for throwing out all 23,000 people en masse, unless we come to the conclusion, that the process is so tainted by fraud that the entirety of the selection has to go?
But that would be my submission if your lordship allows me to.
Now, point number 2, which we wanted to identify. One second. Mr. Gupta, do we have, is there today an identification of those persons whose appointments are one, illegal, in the sense of the OMR issue, rank jumping, beyond the number of recommendations after the expiry of the panel?
Absolutely.
Entirely on the basis of hard disks. The entire thing is on the basis of free hard disks which come from a source which is completely...
Hard disks are accepted by...
How can that be a basis? Because ultimately it leads to criminal consequences. No, but therefore, 65B is a very serious...
Look, if we have to, I'll tell you one thing. If we are inclined to take this, to reserve this matter for a fuller consideration. At the same time, we can't obviously, now it's obvious that some appointments are tainted. Right? We are not inclined, we may not be inclined, subject to hearing everybody, we may not be inclined to issue an unconditional order of stay in respect of all appointments. So those appointments which fall into certain clearly defined accepted categories, there can't be a stay in respect of those categories.
Very well.
Right? Now, which are those 4 categories which we'll have to exclude?
No, just one thing, look, working since 2018 and petitions filed 3 years later, 4 years later.
271 of the judge. 271 of the judge.
Millard, let me just summarize the position, Millard.
Just one second.
242, first 2 lines of paragraph 242.
Can you just give us the PDF page, please?
Just may I summarize? I'm not having anybody.
271.
Mr. Maninder, you are living in a bullock cart age.
Yeah, I asked my friend Millard, I didn't.
What? Your friend, you should have an iPad now.
Millard, may I summarize?
Para 242, if your lordships have it, Millard, first 2 lines. First 2 lines in para 242.
Otherwise, Maninder, go and take some training in the Delhi High Court. You'll get some good training online. This is not acceptable.
We will, Millard. 242, first 2 lines. Para 242.
Mr. Dave, are you also in the same category or?
Millard, 242.
Just give me the PDF page. Anybody who has the PDF page, please tell us.
200.
All right, just look at those. Para
242 of the judgment.
You want to read 242?
It should be PDF 242. I'll come to 242, I'll read 273, then come to 265, just permit us.
Yes.
242. If your lordships have got it, Millard.
Yes.
In course of hearing, SCC did not discount the fact that possibilities of further illegalities exist. Now, before I go to 265, come to 273 straight away. 273. Because there are 3 authorities, all 3 have raised hands and candid that we cannot give you the total number. Please see 273. Yaar, 1 minute, bhaiya. SSC had 273. PDF 260. 273.
Yes.
SSC had no stage of hearing claimed that it was able to check all the records and be definite as to the number of illegalities in the recommendation made, but had limited itself to those figures as stated in the paragraphs above. In fact, reports in the form of affidavit filed by SCC from time to time had always stated that they discovered the illegalities as were brought to their notice by the litigants or an order of the court. This is number 2. Kindly now come to 265.
Before that, if not, you can take
now just 265. Para 265. 257 is the PDF page number. State government therefore has accepted there were widespread illegalities in the selection process. Now, these are admitted facts, Lord. Nobody has disputed it. And that the number of persons who received appointment illegally could not be determined with exactitude. So this is the foundation, my Lord, in your Lordship judgment that the entire thing has to go. They had resolved to create supernumerary posts to accommodate the illegal appointees. In other words, state has resolved to expend taxpayers' money to accord sanction to an employment secured dishonestly
such course of action of the state violates section 14. Other two paragraphs, my lord, say that the SSC says we have not made recommendation. Board says I have appointed on recommendation. Recommendation don't exist. And impossible to find out how many cases. And SSC admits candidly in its report, in every report, I have conducted this number and determined on the basis of the complaint received from the candidates and, my lord, the agency.
No.
I am reading only from the judgment. And there is no ground that, very well. Now, my lord, kindly see only 2-3 paragraphs more.
Para 33, that's
Kindly, my lord, kindly come to 257, para 257, role of the state government. PDF page 253, para 257. And, my lord, your lordships were told no criminality has been found. A application for sanction for prosecution of the state officers is pending. When the High Court asked, by what time you will decide sanction, they said after the election. Kindly have a look, my lord, 257. The role of the state government in the writ petition and the appeals have been heard by us has to be taken into consideration. And your lordship may also keep one thing in mind. In addition to CBI, there was an SIT and the CBI to work with the SIT. SIT having sought sanction is in para 258. Complete evidence of illegality. And the argument on the other side which you were hearing, my lord, no illegality. Kindly see, my lord, 257. No, kindly, I'm sorry, I'm so sorry.
Our question is very pertinent. Today we are trying to consider whether segregation is possible or not. Just come to internal page 240 of the judgment, which will be para 305 of the judgment.
Yeah, where this is CBI report is quoted.
And CBI report has been reproduced by undeserving candidates. That's your case. This mismatch establishes. Now, the entire thing originated from residents of Bansal when those OMR sheets were recovered. And that is the reason why you have obtained 65B certificate also from him. Data is recovered
That
from
is CBI.
He has to say something, correct?
No, that would be CBI.
Right.
I appear for a candidate, not a writ petition.
Fine. Just make us understand. Last 5 lines at 240. The comparison of
these actual genuine OMR marks.
So now there are 4, just 2 minutes. There are 4 categories. There is manipulation in 952 numbers of candidates of Roman 9-Roman 10, 907 numbers of candidates of Roman 11-Roman 12, 3481 numbers of grade C candidates, and 2823 numbers of grade D. Who are these candidates? Who are these candidates? What are the names of these candidates?
That the commission has to give it to your lordship.
No, we have the names.
No.
We have the name.
We have the names.
No, what I'm just.
That the names and the roll numbers of the candidates.
The more important question is not who is Pankaj Bansal. He never had custody of this. They've taken hard drives from an ex-employee who CBI itself says that he was not the person in custody. Niladri Rai was.
On the hash value, the hash value has to
Main thing here is one sec.
That in the same report, earlier paras of the same report shows that Niladri Rai was from NISA who was in charge of this. Pankaj Bansal was never there. And an ex-employee who is illegally holding on to some hard drives, those hard drives procured by him, they take a 65B certificate from him.
Then
The accused person, an accused person who is never in custody.
If with regard, Lord, if with regard to every candidate, there are two OMR. One with the lower number and one with the increased number. That's the end of the matter, my Lord.
Only on the basis of an illegally hard drive.
The only thing is that can that be said about every one of those?
That's what I am respectfully submitting, my Lord. That the commission says I have not examined the entire record. Whatever examined, this is the result. Let them examine fully.
SSC come
Number
forward
one.
with a statement before they go to an affidavit who are genuinely done. We have to come with that.
The number two, my Lord, the state is castigated here. Kindly have a look at the state, my Lord, what the High Court has found.
If the SSC says they are genuine, they're genuine.
If, my Lord, the OMR is, for every candidate, there are two OMR, the entire case be done afresh.
ওই যে অ্যাফিডেভিটটা বার করতে হলো বার করতে পারলেন না ওর লাস্ট অ্যাফিডেভিট আমরা করতে পারছি না ফাইনালি যেটা আমি দেখি যেটা রেকর্ড করেছি
Lordship, my lord, if my learned friend, my lord, if your lordships can come to page 243,
Yes, my lord.
PDF. I don't have the papers, my lord. I am not given the papers.
Before that, my lord, the lordship is just keeping in mind, my lord, various cases have come up with regards to this kind of a illegality. And the illegality modus operandi which seems too common is, my lord, that the original OMR within the commission, blank OMRs, my lord, where the candidates' numbers are changed are always either in the chairman's house or somebody who's close to chairman's house. They are all caught for, or they collected from there. But the point which is, my lord, what deserves your lordship's consideration is that if, my lord, in the table at page PDF 243, if the illegality is from 10% to 45% in the OMR, with the advocate statement of the commission, state as well as the board, that the entire record has not been examined without examination of record, if the OMR inconsistency is between 10% to 45%, in 4 exam, my lord, it's a classic case of calling for a fresh election. And number 2, yes, 1 second now.
Pilot will. But
who is the statement to make a decision on my behalf?
1 year later, now that the OMR seats to be destroyed.
The FCI was
They want to argue.
1 second.
My lord, the argument of 4 years and 5 years has been raised. My lord, in the judgment of Honorable the Chief Justice, my lord, in that FCI case of 2017, that where, my lord, caste certificates were false. And, my lord, Constitution bench believed that given a benefit to a postgraduate medical student, which fell for your lordship consideration, that is, my lord, reported as 2017. My lord, I give you this much of your lordship
Just 1 second. Just 1 second.
Lord, just 1 second. My learned friend will permit me to give the citation, my lord. 2017 8 SCC page 670, para 24, my lord. Your lordships have reaffirmed R. Vishwanath Pillai, where when your lordship came to the conclusion that the gentleman took appointment on a false certificate, 27 years he had worked. Your lordship set aside the judgment, and in this judgment, my lord, Vishwanath Pillai judgment has been confirmed. These are all those cases.
So actually,
may I?
Actually, on various. Not been considered by the court.
13. Kindly comes to para
5 years to
judgment.
If your lordship may have, my lord, of 2017 8 SCC 670.
This is 65B. Lord, it is completely
only to ensure that no manipulation is done.
No, this case is a case of 120B. I don't know why they are stuck at 65B. The case has traveled to 120B.
What 120?
65B has a
Your
different
case
purpose.
is only on a piece of evidence which is inadmissible.
The 65B for a different purpose to ensure no manipulation is produced. And you have looked into it, did not dispute.
The OMR is only from that.
This judgment will assist your lordship.
Para 34. Para 34, 24, my lord, 2
But
4.
CBI has no role to play here. I don't know why my friend wants us. Lord, we like to be heard first.
I need, my lord, four. Yes, my lord, just permit me, I am completing, my lord, 43 PDF 243, that table. That table, my lord, 4 stream, and the illegality found, even whatever is found, is from 10% to 45%, coupled and blended with the statement made before on oath, before the Honorable High Court by the board, by SCC and by state, that this is not the complete figure. Illegalities are more, which more and more records you detect, you will find more. Number one. Number two, Lord, the period of spent after illegal appointment, which is void, has never found favor with your lordship in any case. And this para 24, Lord, para 24 of your lordship judgment in FCI, which I have handed over. Just have a look at para 24. I just want to show one line. Just one line, my lord. 27 years. After 27 years, your lordship held in R. Vishwanath Pillai that the appointment was void. Therefore, the working for 4-5 years, 27 years will not make any difference. Number 3, my lord, the sanction sought by the SIT. SIT, my lord, is appointed first. The sanction sought by the SIT against the state officer, the High Court asked them, what time you will decide this? They said after the election. And the since another bench has already passed an order, we would not like to do it. So, my lord, to argument there is no criminality, when simultaneously sanction is pending, is no argument. Lastly, my lord, when the matter came up earlier, your lordship did not say investigation. Investigation is all the more necessary when the bodies concerned with the appointment and making recommendations are not taking any responsibility. Everybody says, I wake up when I receive the complaint. And therefore, I will do a limited inquiry. I will not give you the full record. So, 10% to 45% in 4 streams. If that is the extent, my lord, where they say further illegalities can be found, it is a fit case, my lord, where everything must go and there should be a proper appointment selection. My respectful submission, my lord.
Second, Minister.
I am done, my lord. I don't need more time.
The way we are dealing with the nitty-gritties of the matter.
Defensible.
My lord, there are...
One second. You are...
CBI inquiry.
Mr. Dave, we are not here, Mr. Dave, we are not here scrutinizing the conduct of Justice Ganguly. We are, throughout the morning, we've been addressed on the nitty-gritties of the issue by both the sides. So let's confine it to that today.
Lord, we have...
What he said and what he did. Purely Pinochet principle.
1 second, let me talk some.
Investigation goes. The CBI investigation. The CD goes.
In fact, my investigation is right for दे दो ना यार.
Not the CBI report.
वहाँ आगे बढ़ के दे दो. डर से क्यों? Give it to them.
I appreciate that.
नहीं क्यों कहूँ?
But this is not
one second. Just 1 second. If we look, unless we have maintained some order, we'll never get.
Lord, we didn't even speak a word when they were arguing.
All right, what we'll do is we'll place this in July. We'll just issue notice and place this in July. That's correct. There'll be no stay of anything. Either we are staying.
Can I say one job? Can I say job?
We find that it's impossible to
give us 5 minutes each.
It's impossible to have an orderly hearing. Yes. We will just simply issue notice. This is in July.
Lord, we didn't open our mouth when they were arguing.
In the morning, we have had very ordered arguments. Now we find that there's only a slanging match going on.
Correct.
We'll simply issue notice, place it in July. No stay of the investigation, no stay of the judgment of the High Court. That's the only way we can.
Lord, kindly don't do that, Lord.
Otherwise,
give us 5 minutes for the petitioner. Lord, we did not open our mouth when they were arguing. And they even not. This thing, please don't say this.
However, 1 second, please. However sensitive the matter is, however politically fraught the matter is, we must understand that we are lawyers here.
Correct.
If we want to be politicians, we can go to parliament, we can go to the state legislature.
We are not
in the court, we are lawyers. We may be on either side of the ideological divide. We don't care as judges about your ideological issues. We are concerned with the legality of the issue.
That's the point.
Right? If so long as everybody just bears that in mind, just leveling allegations against High Court judges, that's not going to carry the penny any further, because we have to decide on the basis
Till that time, your lordship called upon us, we didn't open our mouth. Lord, your lordship called upon us. Follow this judgment. 3 judgments I am handing over, Lord, starting from Krishna Yadav. Krishna Yadav is the first.
Please regulate us. Please regulate us for 2 minutes each. Please regulate us for 2 minutes each.
With this kind of unruly behavior, all that we can do is not a matter to be dismissed. We'll issue notice. We'll issue notice.
We are not
listed after the
We are not doing it. If I can complete in 2 minutes, please have a look at those judgment.
We will
call out names for 2 minutes.
The reason why we said yesterday that we will have an order for counsel to appear is that one counsel will argue at a time.
Yes.
We told you that if we are inclined to dismiss the petitions, we will hear you fully.
Yes.
We are not inclined to dismiss the petitions. Therefore, we wanted to hear them.
My turn is not even.
I will not take by the clock more than 2 minutes. Just 2 minutes. Well, the Lordship will be shocked.
1 minute only. What are these over?
Let's understand what they have.
2 minutes, fellas, by the
1
clock.
minute, Millard, only.
My turn is not even. Mr. Maninder Singh, others will also have.
1 minute. 1 minute.
No. You should, at some point of time, you should stop.
Hearing for a person who is not a writ petitioner.
Yes,
he was
I'm a
not
writ
even
petitioner.
completed.
You don't know. I don't know whether my learned friend is aware for whom he is appearing. I am appearing for the writ petitioner.
2 minutes.
He may be having many clients. I have only one.
One sec.
Lord, may I just say something?
Only one client.
Lord, may I
take one suggestion?
2 minutes.
Without,
2 minutes.
May I just say something?
But in fact, I couldn't open my mouth. So I am the petitioner. Not argue the matter in court below.
It's 2 minutes by the clock.
Yes. We are rising for 10 minutes. We'll come back at 10 past 4 and we'll dictate a short order over here.
Kindly hear us for
Only one.
Our turn has not come.
Issues notice.
Our turn has not
There
come.
would not be.
We were waiting for our turn.
complete. My lord, that's the difficulty.
Sorry?
My lord, something.
Issuance of notice, my lord, would ensure that service is not complete. It would never be heard. My lord. Therefore, that's my concern. My lord, as a lawyer, my lord, I'm saying.
Because there will be too many parties to serve.
We were waiting for our turn. We were waiting for our turn. We are waiting.
Those who are waiting for the turn may be heard.
My lord, a point which is not being made till now.
Your lordship can order publication, my lord. This is not a
Forget
make service.
Well, I am saying 2 minutes. Give 2 minutes.
We'll direct publication because there's no question of individual service. And most important, we have sufficient representation of all different, a variety of interests here. Normally, in a matter like this, if people are unrepresented, there's an issue.
Yes.
We have adequate representation on both sides, including of a varied interest. So it's not an issue.
So allow 2
My
minutes.
category, I have not even been able to open
By
my
the
mouth.
clock. By the clock.
Points that have not
Give
been
us
made.
5
We have not argued. We're waiting in our queue.
All right, 1 second.
2
We'll
minutes
come
by the
back in
clock.
exactly 10 minutes. Now tell us who remains to be.
I will not argue at all. I'll take 2 minutes.
I represent.
I'll take 2 minutes.
After vacation.
After vacation,
After vacation.
I didn't argue.
Please clock it at 2
Not
minutes.
just be here is tomorrow. 5 minutes is all that it.
We'll take it up. We'll continue.
There's too much at stake.
Just 2 minutes.
Lord, the interim order already passed, may be
We'll take it
extended.
up tomorrow.
Tomorrow,
We'll take it up tomorrow morning.
But my learned has given an order.
So we have already come. We have heard Mr. Pratik Dhar. We were following that order. Now the next Mr. Rodgi was not well, so Mr. Madial has argued. Mr. Shyam Diwan has been
Started.
Yes, Mr. Shyam Diwan is on his legs. We are going to follow with Mr. Patwalia, Dr. Murlidhar, K. Parmeshwar, Mr. Dushan Dave, Mr. Giri, Dr. Singhvi, then
In item 27, I'm there.
then Mr. Amit Sharma, Siu Singh. Now, look, if everybody has to argue, we'll not even be able to finish.
Give us
Just 5 minutes. 5 minutes. That's all.
There's no point in.
5 minutes.
Please fix it at 5 minutes. Please fix it at 5 minutes.
By the clock. By the
I
clock,
would
5
not
minutes.
repeat any point. Just 2 minutes on a fresh point which has not been addressed.
Limit it to 2 to 5 minutes, whatever your lordship says.
For the purpose of deciding whether to dismiss the matter or whether to entertain the matter, we have heard enough. We have heard for a whole day. What we are proposing to do is
We are on interim relief.
we are rising for 10 minutes. We'll come back and we'll dictate a small order after that.
1 minute.
I'll take your leave, my lord.
You still have.
No, not.
Hey,
this batch of special leave petitions under Article 136 of the Constitution arises from a final judgment and order dated 22 April 2024 of a division bench of the High Court at Calcutta. In 2016, the School Service Commission in West Bengal conducted selections for the recruitment to 4 categories of posts. Bracket 1, assistant teachers for classes 9 and 10. Bracket 2, assistant teachers for classes 11 and 12. Bracket 3, non-teaching staff of the Group C category. And bracket D, non-teaching staff of the Group D category. A notification for the state level selection test was issued on 16 February 2016. Stop. An OMR-based written examination was held on 27 November 2016. Stop. The final panel for candidates for class 9 and 10 was published on 12 March 2018. Stop. The merit list of empaneled candidates was published on 28 August 2018. Stop. The candidates joined as assistant teachers in or about January and February 2019. A batch of petitions was instituted before the High Court challenging the selection process of 2016. Stop. The selection process for assistant teachers was governed by the West Bengal School Service Commission. Bracket selection for appointment to the post of teachers for classes 9 and 10 in secondary and higher secondary schools rules 2006. 16. Stop. Likewise, there are rules governing the selection to assistant teachers for classes 11 and 12, also of 2016. The selection for the Group C and Group D non-teaching posts is governed by the West Bengal School Service Commission, bracket selection of persons for the appointment to non-teaching staff, bracket rules 2009, page E and F को मिल जाएगा. The writ petitions before the High Court were instituted in 2021. Good stop. From time to time, orders were passed by the High Court annulling the appointments on the ground that the process, on the ground that the appointments were made illegally. Let's stop. The appointments were assailed initially before the division bench of the High Court, and ultimately dispute traveled to this court. By its judgment dated 9 November 2013, sorry, 9 December, yeah, sorry, I said 13. 9 December 2023, 9 November 2023, this court, while dealing with a batch of petitions, directed in Achinta Kumar Mandal and others versus Lakshmi Tunga and others, footnote deke, SLP civil number 4078-4079 of 2023, that all the issues relating to the appointments of 2016 should be examined by a division bench of the High Court. And accordingly, an order of remand was passed, was issued. Accordingly, an order of remand was passed. The order of remand has resulted in the impugned judgment of the High Court. Let's stop. The High Court has held, inter alia, that bracket 1, all appointments made in the selection processes involved were violative of Articles 14 and 16 of the Constitution, and therefore null and void. As a consequence, of the judgment of the High Court, approximately 25,000 appointments. Do we have the exact figure?
25,735. 25,735.
All. Action
All right. Approximately 25,000 appointments would stand to be abrogated, 25,000 appointments would stand to be set aside. Let's stop. During the course of the hearing of the cases before the High Court, there was a direction to the Central Bureau of Investigation to conduct an investigation in regard to the alleged illegalities, in regard to the alleged acts of criminal wrongdoing arising from the selection process. When the matter traveled to this court, the order, the order dated 9th November 2023 directed the CBI to complete its investigation within 2 months and to submit a report to the High Court. In the meantime, this court directed that the appointments which were granted during the pendency, that the appointments which had been made shall stand protected for a period of 6 months to enable the division bench to adjudicate upon the matter. Next. In the earlier order dated 9th November 2023, this court was of the view that the direction of the High Court for the termination of the services of candidates at the interim stage, even before the final disposal of the petitions, ought to have been avoided Full stop. Before the High Court, as indeed before this court in the earlier proceedings, a fundamental issue which arose for consideration was in regard to the admissibility of the OMR sheet images which have been recovered by the CBI Full stop. The court noted that the investigation by the CBI was yet to be completed. Full stop. The admissibility of the OMR sheet images being in question, this court observed that the question of the exercise of power in relation to the discovery of electronically stored OMR sheets implicated serious allegations in regard to the manipulation of records, having regard to the number of persons who are likely to be affected by the outcome of the proceedings, it was considered appropriate to remand the proceedings back to the High Court for a final decision on the writ petitions. Before dwelling further on the ultimate directions which have been issued by the High Court, it would be necessary to note at this stage that and it would be necessary at this stage to make a brief reference to the report dated 5 February 2024, which was the last report, which was the last report, which was the final report which was filed before the High Court. The report of the CBI notes that the West Bengal School Service Commission, into brackets WB-SSC, the other side SSC, had awarded a work order to a company by the name of NISA, NYSA Communication Private Limited, for scanning and evaluation of the OMR sheets pertaining to the selection tests for each of the 4 categories. The scanning of OMR sheets was undertaken by the aforesaid company at the office of the SSC. It further emerged during the investigation that the company Data Cantech, SCANTECH Solutions Noida, which was present at the premises of the SSC for completing the scanning work. According to the CBI, after completing the scanning, the processed data in the form of scanned images of the OMR were handed over by Data Cantech Solutions to NISA Communications Private Limited. In the digital form, leaving the original hard copies of the OMR sheets in the office of the SSC. According to the CBI report, the SSC handed over the answer keys for all subjects to NISA Communications Private Limited for evaluation of the OMR responses. CBI seized the server database of the SSC during the course of the investigation. Full stop. On 15/16 September 2022, 3 hard disks were recovered from the residence of a person by the name of Pankaj Bansal, a former employee of NISA Communications Private Limited at Ghaziabad. Full stop. Certificates dated 16 September 2022 under Section 65B of the Evidence Act were obtained from Pankaj Bansal. It says 16th actually. The report says 16th. 19th, all right, 19th. During the course of the investigation, data files containing scanned OMRs, among other things, were seized from Data Scantech Solutions. The report of the CBI notes that a comparison of the actual the report of the CBI contains the following observations in paragraphs 12 and 13. ये आप कॉपी कर लीजिए पेज 279 and 280 PDF में मेन मैटर में. The above investigation by the CBI indicates that a comparison of the indicates that it has found a manipulation in respect of 952 candidates for the selection process of teachers for classes 9 and 10, semicolon, in the case of 907 candidates for classes 11 and 12, semicolon, 3481 candidates for Group C, and 2823 candidates for Group D. Full stop. That apart, comma, the report of the High Court notes that chart is para 240, na? Yeah, 240. Can you give me the page? Apart from the above report of the CBI, the impugned judgment of the High Court contains in paragraph 240 a reference to the fact that the SSC had submitted a statistical report of the 4 selection processes tabulating the alleged irregularities. Full stop. The tabulation is reproduced below for convenience of reference. ये आपको पेज PDF page 243 को मिल जाएगा.
Paragraph 271 also.
Yeah, I got it.
271.
Excess appoint.
Yeah. I have it. I've made a note. I was coming to it in a second. 259 now. The High Court has also noted that in response to its queries, the SSC had submitted details of the recommendations which were made by it in respect of the 4 categories and the number of appointments issued by the board. Full stop. In the case of classes 9 and 10, in the case of the selection process, don't say that, just say this. The figures submitted by the SSC indicated that the actual number of persons who were appointed by the board was in excess of the recommendations made by the SSC. To the following extent, bracket 1, assistant teachers for classes 9 and 10, -1539, उसके नीचे 2, assistant teachers for classes 11 and 12, -199, Group D posts, -669, and 4, Group C posts, 416. Let's stop. On the basis of the data which was submitted before it by the SSC, the High Court has noted, the High Court has observed, into brackets paragraph 241, that the illegalities admitted by the SSC cannot be said to be within tolerable margins in a selection process of a large magnitude, and that the SSC did not discount the fact that the possibilities of the existence of further illegalities may still exist. The High Court further noted into brackets para 273 that the SSC had not been in a position to state that it had checked all the records so as to be definitive about the number of illegalities The state government had also accepted that there were widespread illegalities in the selection process. Full stop. The next, on 19 May 2022, the state government the state government, the government of West Bengal, in the school education department, issued an order in exercise of the power, in exercise of the provision, in exercise of the power conferred by Section 19. Don't say in exercise. Creating 6861 supernumerary posts of teachers and non-teaching staff for absorbing waitlisted candidates and directed that appointment letters to such waitlisted candidates should be issued in terms of the recommendation of the SSC, subject to the outcome of the pending litigation before the High Court. The court has been apprised during the course of the hearing that a petition under Article 226 of the Constitution WP capital A 250-256/2022 has been instituted before the High Court to challenge the order of the government creating the supernumerary posts to accommodate the waitlisted candidates is pending before the High Court. In this backdrop, the High Court, by its impugned order, has, while setting aside the appointments, directed that bracket 1, the OMR sheets available in the 3 hard disks must be uploaded on the website of the SSC. Two, persons who had been appointed from outside the panel, after the expiry of the panel, and against the submission of blank OMR sheets, must return all the remuneration and benefits received by them to the state exchequer, together with interest at 12% per annum, failing which recoveries, the outstandings would be recovered as arrears of land revenue. Semicolon, bracket 2, the CBI shall interrogate all persons who had received appointments beyond the panel, after expiry of the panel and after submitting blank OMR sheets, if necessary, by undertaking custodial interrogation. semicolon, bracket 3, CBI shall undertake a further investigation with regard to the persons involved in the state government who had approved the creation of supernumerary posts to accommodate illegal appointments, if necessary, by conducting a custodial interrogation. Semicolon, bracket 4, the SSC shall undertake a fresh selection process as a consequence of the vacancies which are declared on the setting aside of the appointments. Full stop. Other consequential directions have been issued. Next. The primary question which has been urged in the course of the hearing by the learned counsel appearing on behalf of the petitioners fall under four broad heads. Bracket 1. The data on the basis of which the High Court has set aside the appointments of nearly 25,000 persons, including assistant teachers and those appointed to non-teaching Group C and Group D posts, is itself suspect. Since the foundation of the entire exercise is the certificate under Section 65B issued by Pankaj Bansal, a former employee of NISA Communications Private Limited, from whose possession the 3 hard disks were seized. 2, in a selection process having such a large magnitude, cancellation of the entirety of the select list should be a matter of last recourse. And whereas segregation of the tainted candidates is possible, only such appointments should be directed to be discontinued. 3, the above consideration must apply a fortiori in a situation where the petitions were filed nearly 3 years after the appointments were made, and the direction, particularly because the direction to set aside the entirety of the appointments would have serious repercussions to employees who have served the state. And 4, while there can be no four, where the appointments which are tainted are capable of being identified, comma, it would be manifestly unjust for the High Court to set aside the entire selection process. Stop. On the other hand, comma, it has been urged on behalf of the respondents who have supported the judgment of the High Court that both the SSC and the state government were not in a position to specifically identify we're not in a position to state that the possibility of further illegalities can be ruled out. Stop. In this backdrop, when a systemic fraud has vitiated the entire process, comma, the High Court was justified in setting aside the entirety of the selection process. Next. We are of the view that the submissions which have been raised on behalf of the petitioners would merit further consideration. But stop. The issue pertaining to, don't say the issue pertaining to, the certificate under Section 65B of the Evidence Act was issued, comma, as the CBI report notes, comma, by Pankaj Bansal, who was a former employee of NISA Communications Private Limited. But stop. The legitimacy of the certificate, which has been obtained from the above individual, would prima facie lie at the root of the data which forms the basis of the judgment of the High Court to set aside the entirety of the appointments. That apart, comma, from the material which has been placed on the record before the High Court by the SSC and by the CBI during the course of its investigation, it would emerge that the appointments which suffer from taint from what did I say? From the material? Question from the course of the investigation, comma. A further issue which would merit closer analysis is as to whether the appointments which suffer from a taint can be specifically segregated. Full stop. If such an exercise is possible, comma, it would be unfair to set aside the entirety of the selection, which extends to as many as to approximately 25,000 appointments. Stop. The court cannot also be unmindful of the impact of the setting aside of a large complement of assistant teachers who have been recruited for both class 9 and 10 and class 11-class 12 students, which would be the consequence if the impugned judgment were to be upheld as it stands. But stop. Assuming that such a segregation is possible, this court would have to determine the modalities which would be followed for that purpose. But stop. At this stage, the court must be guided by the fact that by its order dated 9 November 2023, this court had protected the appointments which had been granted subject to the direction to the High Court to expeditiously dispose of the writ petition. Full stop. Bearing in mind the High Court, bearing in mind the present stage of the matter, we are of the view that an expeditious and early disposal of these proceedings would be in the interest of justice, and we accordingly direct that the proceedings be listed for hearing and final disposal on 16 July 2024. Stop. In the meantime, we are inclined to continue the ad interim protection which was granted by this court in its order dated 9 November 2023, subject to the express stipulation that persons that any person who is found to have been appointed illegally and is continued as a consequence of the present order shall undertake to refund the entire amount of the salary which may be paid between the date of this order and the final judgment of this court. Full stop. This would cover illustratively the 4 categories of individuals noted earlier, namely, bracket 1. We need not, we can just say for the 4. In paragraph 240 of the judgment, which has been reproduced.
Your Lordship have not said anything about the state sub.
Now with this something. On the earlier date, the High Court has, by its impugned order, directed the CBI to investigate the creation of supernumerary posts at all rungs of the state government. Full stop. The above direction of the High Court was stayed by this court.
You didn't stay that, only said no precipitory action taken.
This court, by its previous order, had directed that no precipitate action would be taken in
Clause 8 may be stayed.
In pursuance of the direction contained in Clause 8 of the operative directions of the High Court, which is reproduced below. Just give the PDF page, please, of that.
We'll give it to the court master. 281, my lord, possibly.
Para 363. Para 363. Clause 8.
Mr. Rakesh Dwivedi and Mr. Jaideep Gupta, then Mr. Rakesh Dwivedi appearing on behalf of the State of West Bengal.
And Mr. Neeraj Kaul.
And with Mr. Neeraj Kishan Kaul, Learned Senior Counsel, stated that as a matter of fact, no appointment whatsoever has been made in pursuance of the order of the state government dated
19th May 22.
May 2022, which in any event forms the subject matter of a pending writ petition before the High Court, where the creation of the supernumerary posts has been stayed. Full stop.
Except one, Lord, that was.
No, that was
a
cancer patient.
Which even this division bench has upheld.
However, it appears that there is one exception has been made in the case of an individual
that is not
on medical grounds.
Soma Das.
That is not a supernumerary post, right? All right.
It's the supernumerary
That's
post,
all right.
Soma Das.
That's all right. Nobody is setting aside her appointment, right? Don't say that. The earlier order of this court, in regard to the above direction of the High Court, shall continue to remain in operation.
I'm great.
Pending the subject to the aforementioned subject.
We are giving undertaking.
To the above, subject to the above stipulations, the judgment of the High Court dated so and so shall remain stayed till.
Judgment also directs us to further investigate. Directs CBI to further investigate.
That has been stayed.
The investigation in regard to the creation of supernumerary posts.
No, my lord, your lordship staying the order would stay the CBI investigation as well.
That's only in regard to the supernumerary posts.
Kindly see, Lord, 7 is only a minute. Lord, I have not said anything, but let me say it. Lord, kindly see 7.
Look, we will not stay clause 7.
I'm not concerned with 7.
All right. The direction, we however clarify that the direction contained in operative, that the following direction which has been issued by the High Court in operative direction 7.
And 9, my lord. 9 is to file report.
Not 7 again, there are no appointees to make custodial interrogation.
No, 7 we will not stay because 7 covers 4 cases who had received appointments beyond the panel.
Yes.
After the expiry of the panel, submitting blank OMR.
I'm sorry, Milord. I'm sorry. Sorry, Milord. On that, our
Custodial interrogation.
Milord, there has to be, my lord.
We, however, permit the CBI to continue its investigation in respect of bracket 1, persons who had received appointments beyond the panel, semicolon, bracket 2.
Dispute. I'm sorry,
persons who were appointed
I have stay of this.
That's seriously in dispute, my lord. We have challenged.
We should go those who have been identified.
My lord, let 16th of July, my lord, the judgment as such will be stayed. Sorry.
No, investigation.
All right, Aisaliko, in modification of the previous order, we direct that the investigation, which has been ordered by the High Court, pursuant to clauses 7 and 8 of its operative directions, in paragraph 363, by the CBI shall continue, but no coercive steps shall be taken.
Not 8.
Not 8, my lords.
Why?
My lords, 8 involves the cabinet.
That is supernumerary, my lords.
8 involves supernumerary, the cabinet force. And that's why your lordship stated. The lordship says 7 and 9, not 8, my lords. That is people who prepared the cabinet.
They identified illegalities. No,
7 and 9.
We have said 7. 9 is an adjunct of 7.
Yes.
8 in regard to the creation of supernumerary reports we have stayed right now.
The lordship may just clarify that. That's all that we are saying.
Just one second. The supernumerary posts, we have recorded the statement of the government that not a single appointment has been made to a supernumerary post. And that's the subject matter of a pending petition before the Calcutta High Court, where that has been stayed. And insofar as the other categories are concerned, in clause 7 of the order, we are permitting the CBI investigation to continue, subject to the stipulation regarding clause.
It's a grant.
Chalo.
My lord, item number 8.